Well, a warm welcome to everybody joining us this afternoon. Our subject today is procurement law in 2022. And where do you stand in terms of that? And as quantity surveyors, the subject of procurement is very important to us. And it's a subject that we do need to give extra attention to. So it's a real privilege to be able to tackle that subject today. So as you're joining, just remember that you are welcome to post your questions in the Q&A function, which you'll find at the bottom of your screen. If you have a question, please post it there. And our presenter, who I'll introduce in a moment, will look there for the question to address. So to say to you, a good welcome again, because I see the numbers are growing as I speak. All of you who live in Harrismith, you had a really white weekend, we noticed, and it was quite incredible to see all the snow that is falling in the Vereenens Pass, Harrismith area. But I trust you're nice and warm and settled in for today's webinar and ready to go. So let me introduce our speaker. Our presenter today is from Cox Yates Attorneys, Peter Barnard. Peter has previously spoken to us as an association. The last time it was related to site invasions, and if you recall, it was an extremely interesting and stimulating 1 hour with him. And today he's going to speak to us about procurement law. And just to give you some background on Peter, Peter joined Cox Yates in 2010 as a candidate attorney, whereafter he was appointed as an associate. In 2015, he was appointed as a partner. Peter completed his LLB at the University of KZN in 2009 after matriculating from Durban High School. Apart from general commercial litigation, Peter practices and specializes in construction, engineering, and infrastructure law, and deals extensively with procurement-related issues and site invasions. Peter was appointed as a member of the Joint Building Contracts Committee drafting panel in January 2018. So Peter comes well prepared, got a great background, and his areas of specialization speak 100% to us as professional quantity surveyors. So Peter, over to you. The next hour is yours.
Thanks for that, Carl. Good afternoon, everybody. Thank you for taking the time to be with us this afternoon, and I hope that I can fill you in on what's been happening in this area of law over the past few months, because it has been quite a tumultuous period. I'm assuming that I'm screen sharing and everyone can see this.
Yep, we can see you, Peter.
Perfect. So as a starting point, like most things, the origin of these issues finds itself in the Constitution, because the Constitution is obviously one of the cornerstone pieces of legislation that we have in current South Africa, from which the majority of other subordinate legislation stems. So this section is probably familiar to most of you, and it records that where government wants to obtain or procure services, it has to do so in a system which is fair, equitable, transparent, competitive, and cost-effective. And it is from those 5 terms that most of our procurement law has emerged. And what I'm going to take you through over the next hour is how the procurement law has been continually changing and shifting, and where it currently stands and what challenges it is currently facing, as well as my thoughts on where it is trying to go. And what you'll find is that this should be of interest for those of you who procure in the public space, for those of you who put bids together for government or parastatals on behalf of projects that they want to execute, alternatively, those of you that are interested in trying to shape legislation through public participation and input. So like I say, we start at the beginning with this extract from the Constitution, and those 5 cornerstones: fair, equitable, transparent, cost-effective, and competitive. From there is where the Preferential Procurement Policy Framework Act, the PPF Act, came from. That act in itself is incredibly short. It's only about 2 pages long, if you want to take the time to Google it and read through it. But what it records is that an organ of state, which can be municipalities, departments, parastatals, etc., have to determine a procurement policy system and then give effect to that. And you'll see here under B1 and B2 that they talk about certain contracts with a maximum amount, a certain prescribed value, having to be awarded 10 points for some type of preference, and then 90 points for price. And I'm sure the concept of 90-10 and 80-20 is not lost in any of you. This is where it comes from. This is where it finds its origin. And this is effectively the balance of the Act. It also records that they can try and award points to somebody who doesn't score the highest number of points, provided that the additional criteria that they want to take into consideration is referenced in the tender document. So you'll see that under 2.1f, the contract has to be awarded to the person who does the best, or the entity that does the best on 80-20 or 90-10, unless there are additional or objective criteria which have been contemplated to give effect to. And you'll see under E as well, that if there's any goal that government or parastatals want to achieve that would justify a deviation from the ordinary 80-20 or 90-10 principles, then that has to be set out in the tender document. So, for example, and I don't want to foreshadow what I'm going to talk about, but you'll often find in tenders that it'll be recorded, well, we're operating on this 90-10 system, but we want to award extra points for this objective or that objective. And provided that it's rational, provided that it is measurable, and provided that it is recorded in the tender, that is something that government and parastatals can do. Just before I move on, I also just want to make it clear, and it should be fairly obvious, but sometimes not, that these laws and these regulations only relate to government and parastatals procuring. If some of you are acting for private clients, private developers, private contractors, etc., these laws and regulations don't feature. You can put whatever conditions you're in. You can use 90-10, 80-20, but you can give it to the guy who is the most expensive with the lowest BEE score if you so wish. This is only legislation which binds government and parastatals, and this obviously doesn't feature in the private sector. So we had the 2011 regulations, which gave effect to this Act, because what I've put up in these two preceding slides is effectively the entire Act. You'll see that it's rather short. There's another 1 or 2 sections, but this is the gist of what the Act suggests. And this Act, by virtue of it requiring organs of states to determine their own preferential procurement policies, that is what gave rise to the regulations, which then have to be read in conjunction with the Act. We had 2011 regulations, which then got replaced and peeled and replaced by the 2017 regulations. And I'm going to talk through some of those now. Under the 2017 regulations, we had a few concepts that are relevant. One, the concept of when you have to use 80-20 as opposed to 90-10 for contracts of 30,000 up to 50 million, quite a big increase from the 2011 regulations. You have to use 80-20. By that, I mean 80 points for price and 20 points for preference. And then on 90-10, same concept, 90 points for price, 10 points for preference. That applies for contracts with an indicative value of 50 million and above. And what the 2017 regulations recorded is that either up to 20 or up to 10 points could be awarded based on the B-BBEE score contribution of the bidder. So that was some of the first things that these regulations introduced, and there was no real challenge with that. There were, however, some novel concepts that were introduced under the 2017 regulations, which did have a significant impact on the industry and did give quite a few people a cause for concern. I remember actually hosting a whole series of seminars when these regulations came out, because I thought that some things they were doing there might be problematic. Regulation 4.1 is one of those areas that I had a problem with. And that suggests that where an organ of state wants to apply pre-qualifying criteria, well, then it must record that in the tender document. But have a look at A. It says that a tenderer must have a stipulated minimum BEE score. Now, I struggle with that because we've just spoken about 80-20 and 90-10, which is a concept whereby you take the scores of all the bidders, you then rank them, and you then look at their corresponding BEE score and you attribute that to a value of points based on 20 or 10, if it's an 80-20 or 90-10 principle. That is the way that the legislation through the Act and the regulations effectively balanced the concept of promoting a healthy and developing BEE score while still ensuring cost effectiveness. That was the way this 90-10 and 80-20 system came about. But now by introducing this concept of a pre-qualifying BEE score, you can cut a whole bunch of participants off at the knees. So government could have said, for example, if you do not have a BEE score of 1 or 2, do not participate. And I think that was a problem, because that then skews the whole scoring system of 80-20 and 90-10. They also went on to record that the bidder might have to be an EME or a QSE, or that the tenderer must subcontract a minimum of 30% of the work to a list of groups that I have up on the screen here. EME or QSE, which is either 51% owned by Black people, youth, women, Black people with disabilities, rural undeveloped areas, etc., etc., etc. So through these 2017 regulations, these were a series of criteria that were added in addition to the 90-10 or 80-20 principles, suggesting that there could be a pre-filtering process to filter out bidders before they even got to that scoring level. There was then another regulation, it was Regulation 9, which was also problematic. Firstly, in its wording. So Regulation 9.1 says that if feasible, which seems to provide some sort of discretion in terms of its wording, if feasible, to subcontract for a contract over 30 million, an organ of state must apply subcontracting to advanced designated groups. Now, I struggled with that because is it discretionary? Because if it's feasible, or if it's over 30 million, must you do it? I don't know. In practice, it would appear that it's something that was taken as mandatory, but that wording is a little bit ambiguous, because what happens if it's not feasible to do so? Then must you do it? And what Regulation 9.2 then records is that the tender has to be advertised, indicating this 30% and who it has to be subcontracted to. Again, we see a reference to an EME or a QSE, and it's the same sort of list which we dealt with earlier. EME or a QSE, 51% Black-owned, youth, women, disabilities, etc., etc., etc. So for starters, government could impose restrictions on who could submit an offer. You might have to be a certain type of company with a certain BEE score or a certain level of employment or management to even get your foot in the door and be able to participate. And then if you want to participate, you have to confirm and demonstrate how you intend subcontracting 30% to these various groups as the tender may stipulate. Just to pause and explain, for those of you who don't know, an EME is referred to as an exempted micro enterprise. In a building sense, it would be a contractor who generates under 10 million, or in your world, a professional who generates under 6 million. And then a QSE is just one group up. So for a contractor to be 10 to 50 million turnover, and a professional between 6 and 25. So that would be the definition of who would be an EME or a QSE. I also struggled with this notion of 30%. I want to go back to that slide. So you'll see Regulation 9.2 is somewhat ambiguous as to what that 30% of the value of the contract means. And I think that hasn't been thought out too thoroughly. Because if you're suggesting 30% of the value of the contract, I presume in the drafter's mind, what they anticipated was that 30% of the work would be given out. But of course, we know that 30% of the value does not equate to 30% of the work. You've got escalation built in, you've got P's and G's built in, you've got materials built in, you've got overheads built in, you've got specialist subcontract work that you simply can't give out. And because of that, this 30% of the value can equate, you're all QSs, you'll know better than I would, but I estimate it would end up by attributing 50 to 60% of the actual work to be done, which is in itself is problematic because that's not what was clearly intended by this regulation. I also just want to mention that this 30% is what often gave rise to the expectation from business forums that they had some kind of entitlement to work because of 9.2. They must subcontract a 30% to various groups, and these business forums latched onto that 30%, which led to their understanding or their preconceived notion that they had some sort of entitlement to that work. but I'm not going to digress and start talking about business forums. What these 2017 regulations effectively did was create a 4-tier evaluation process. You start off with eligibility. Is the bidder even eligible to participate in this tender? BEE certificate, tax clearance certificate, workman's compensation, etc. Have they given you everything they need, that they just tick the boxes, that they can get their foot in the door? If you can get through that threshold, we then have this pre-qualification criteria, which may or may not be there. Are you, Mr. Bidder, an EME or a QSE? Are you a QSE who has 51% black ownership? Do you have a BEE score of 2, etc.? And if you didn't fulfill any of those criteria as stipulated in the tender, your bid gets thrown, your bid gets thrown in the bin. We would then have functionality, which would be whatever additional criteria was set. Can you achieve the objectives? Do you have the necessary qualifications? Do you have the suitably qualified staff? Do you have the requisite experience, resources, capital, etc.? And we then get to price and preference, which is, of course, your 80-20 or 90-10. So that was effectively what the 2017 regulations did to bolster the Act. And I'm just going to jump back a few slides. Again, that Act was very brief. These 2 slides effectively contain pretty much everything that was in the Act. And all that the Act dealt with was 90-10, 80-20, and the concept that if government wants to detract and differ from the 80-20 or 90-10 highest point scorer, well, then they had to have additional goals, which they had to indicate in the bid documents. Everybody saw what they were, but how they would be deviating. So that is what the Act required. And I also just want to reiterate that it was supposed to be an organ of state that had to determine effectively its own preferential procurement policy. And what we then saw from these regulations is that they went quite further than what was initially intended by introducing all these concepts of pre-qualification criteria, being able to cut tenderers off at the knees if they don't meet the thresholds, subcontracting 30%. It was quite far removed from what was initially required under the Act. And the Minister of Finance was going quite far with this. So before I move on, I want to look at this chat and see if there's anything that I need to reply to, which is general greetings, Q&A. This is BE professionals are desperate for work. This has led to pricing for professional services that are far, far below what can be considered being competitive. However, my view is that government are not complying with their own requirements. Yes. So thanks, Stefan. That, I don't know if it's Stefan Christopher or Christopher Stefan, but thanks, Stefan. It's a very poignant issue. There is in any tender an argument to be made for risk assessment. And we all know in all of our lives, be it through bids that you've participated in or contracts you've had to oversee, of failing contracts. Because as we've just seen, people come in at a price that clearly cannot result in the work being executed. But under this 90-10 or 80-20 system, they have to be appointed because they score the highest number of points. There is an inherent basis for the bid adjudication committee and the bid evaluation committee to look at a tender, to see that it is so out of kilter that it poses far too much of a risk for government and that they should simply not proceed to appoint that person. And I think in new regulations to come into effect, alternatively in a new act to come into effect, I do think that needs to be given effect to. You don't want to have a situation, however, where, for example, WBHO has a stellar track record. Everybody knows how well they can perform. And effectively, whatever price they come in at, you'll take them because you know you'll get the job done properly. That also can't be right, because that then doesn't give effect to the intention of the Act, which is fair, transparent, cost-effective, competitive, etc. You can't just take the biggest, strongest, best organization every time. So there does have to be a balance. And the idea behind that was introducing this functionality criteria. Can you get the job done, or do you pose too much of a risk? And if you pose too much of a risk, you fail at the functionality stage, you don't get through to price and preference, 80-20, 90-10. But if it looks like you can get the job done and you've got the best score, when you consider the price and the BEE score combined, well, then you need to get the work. So those are my thoughts on that. Yeah, so you say they don't do that. Sure. I can't get bogged down with explaining every tender appeal that should take place, because the courts have been inundated with tender appeals. Unhappy bidders who got disqualified, trying to fight to get back in, bidders who are number one, who are trying to retain the contract, bidders who are number two, who are trying to kick out bidder number one. We have entire panels of BAT, bid appeal tribunals, and in courts flooded with these types of cases, with these type of arguments being made. However, for what it's worth, I do want to point out that this might not be an issue for much longer, because as you'll see as I'm going through this presentation, all of these regulations are effectively being phased out. Sia Sangha asks, Regulation 2017-41A, government's intention was to advance BEE. Yes, we may differ on this, but the playing field needs to be leveled one way or the other. I completely agree. My only point on that, and look, I'm not a political analyst, my only point on that was that there is a difference between balancing and disqualifying. So the idea of 80-20 and 90-10 was whoever's got the lowest price and is functional will get 90 points and everyone else then falls under. So if you've got the second highest price bid, you might come in at 88 or 85 points. And your BEE score will then get you the winning up to 10 points down to 1. So if you have a great price, but you have no BEE score, you won't come out on top. You could be second or third in line on price and you have the best BEE score because you're focused on transformation, you then win. That was the intention behind the legislature of creating the principles of 90-10 and 80-20 under the Act. Where there was a concern that the Minister of Finance had gone too far was to suggest that in addition of that balancing act, the tender could say, if you do not have a BEE score of level 1, don't even submit a bid, we won't consider you. And that is something that came under attack and something that was considered in these regulations. Right. So I want to now move on to what has happened in the courts, because these regulations and the issues that I have dealt with were in fact dealt with by the courts in recent legislation. So Agribusiness went to the High Court, and the matter then went on appeal to the Supreme Court of Appeal, where they challenged the regulations, 2017 regulations that had come into effect. And I've quoted from the case, and I've just highlighted in 4 different colors, the main points or the main issues that were dealt with. So the first one is they believed that the respondent, who was the Minister of Finance, had gone above his power, ultra vires. He had done too much when reading what he could do under the Act and the Constitution. They thought that these regulations that he had come up with, he was not empowered to create because he didn't have that power conferred on him. He had gone too far by introducing these new criteria. There was also a point that the minister had failed to allow proper public participation. So the association as a general body will recall that when there was the new procurement bill which came out, we in conjunction with the association prepared a whole paper to Parliament on what we thought was wrong with that potential legislation. That's the public participation process, and the Agribusiness contended that wasn't done. There was also an argument made that the regulations were not rationally connected to the information which had been provided and which was not taken into account, i.e., some of these pre-qualifying criteria, etc., were not rationally connected to the objective that government was trying to achieve. And finally, that the regulations which had been adopted were simply unreasonable in respect of what the objectives were. So those were the main grounds of attack that Agribusiness raised. What the Supreme Court of Appeal found, I've summarized here, but they start off by saying, well, this pre-qualification criteria may be considered an antecedent step, i.e. a preceding step to getting, if you don't get over that hurdle, then you don't get into the race under 80-20 or 90-10. Doesn't matter how good you are. It doesn't matter if you are the best contractor. If you don't have a score of 1 and the bid calls for a score of 1, you're out, you're disqualified, you can't even participate in the race. And the Supreme Court found that this new step under Regulation 4, this pre-qualification criteria, added in another layer which the Constitution didn't anticipate: fair, competitive, transparent, cost-effective, etc. And the PPPF Act, or the Framework Act, as they call it here, Preferential Procurement Policy Framework Act, authorizes. Again, that act only really dealt with two things: 80-20, 90-10, and additional goals, which would have to be stipulated in the tender. And the Supreme Court found that the minister didn't have the authority to introduce this antecedent or pre-qualification criteria, because that was not something foreshadowed in the Constitution or the Act, and the minister had accordingly gone too far. And effectively, that the minister had exercised the power of creating these steps, which the minister could not do, because that was something that legislature had to do. Parliament had to do that when giving effect to the Act. So, at the end of that case, the Supreme Court of Appeals struck out the 2017 regulations. And there were quite a few of them that were set, well, all of the regulations were set aside, but 3B, 4, and 9 were critiqued on the basis that this pre-qualification criteria was resulting in too much prejudice and unfairness to bidders, and that the purpose was to advance designated groups, but that was the reasoning for the points. 90-10 was there to advance, or 80-20 was there to advance and balance out groups. You couldn't be chopping off bidders at the knees. And because regulations 3B, 4, and 9 were unlawful, and because the minister had simply gone too far by deviating from what the Constitution intended and the parameters of the PPPF Act by introducing this pre-qualification criteria, the regulations were out. And what the Supreme Court of Appeal did is what they normally do, what the courts normally do, is that the declaration of invalidity, setting aside those regulations, was suspended for 12 months. And the purpose of that suspension was to give government an opportunity to amend or create new regulations, which would then draft, have for public participation, amend, and then publish and ratify and promulgate. So that was the intention. Supreme Court said, right, these regulations do not pass muster. Minister of Finance, you've gone too far. You've introduced things which the Constitution doesn't provide, which the Act doesn't provide. These regulations are gone. However, we will give government a 12-month hiatus, a 12-month breathing space to fix and come up with new regulations. Because if we don't have regulations, if we just have the Act, well, then we're in trouble, because the Act is fairly meaningless without regulations giving effect to it. The Act just says there needs to be 80-20 and 90-10 at some monetary threshold with some type of preference. It's not enough to actually give effect to. So we need regulations in place to make the Act meaningful. So the Supreme Court suspended its order for 12 months on the date that it was given, being 2 November 2020. So what that would mean is that government had until 1 or 2 November 2021 to give effect to new regulations. And if we didn't have new regulations by 2 November 2021, then effectively we would have no regulations at all. That, however, was not the end of the matter, because then the Minister of Finance took the matter on appeal again to the Constitutional Court. So it started off in the High Court, went to the Supreme Court of Appeal, which set the regulations aside, and then the minister took it further, went to the Constitutional Court. And the minister argued there that on a proper reading of 217 of the Constitution, you have to factor in the country's segregated past. I think that was one of the comments that was made earlier by Stia Sangha, that this is not something that is easily fixed. And even though there was this 80-20 or 90-10 balancing act of price and BEE score, which was trying to amortize and level the playing field, that wasn't sufficient. And that the minister had the power to try and rectify, give effect to dealing with the country's segregated past. And this notion of pre-qualification criteria was not offensive on that basis. That's what the legal team for the minister argued. It was also argued that the Supreme Court had made a mistake because it had only read section 217(1) of the Constitution and not the other two subsections. And those other two subsections talk about the effect and the power that the minister has to try and give effect to this notion of transparency, cost effectiveness, etc. In effect, what this meant is that the Constitutional Court had to reconsider all of these issues. And of course, the Constitutional Court, very often more so than the Supreme Court of Appeal, is a lot more focused on the humanitarian elements. issues of the country's segregated past. How does that racial inequality play? How does that need to get dealt with and rectified through the law? That is something that the Constitutional Court frequently deals with. However, in this instance, the court took quite a strict puritanical legal view. There was a minority judgment, so the judges themselves were split. But the majority of judges held the words necessary or expedient. Now, those words appeared from the Act. And the Act said that this Minister of Finance can give effect and implement regulations which are necessary or expedient to achieve the objectives, and that overall, each organ of state, each municipality, each department must determine its own preferential procurement policy. So I'm sure I'm going to give you a bit of motion sickness. I just want to jump back to some of my earlier slides here. You'll see here, an organ of state must determine its preferential procurement policy. This is from the Act itself. The objectives of the Department of Arts and Culture might be very different to the objectives of the Mvoti local municipality, might be completely different to the National Department of Public Works, might be different to health, education, etc. And by the Minister of Finance creating these regulations with preceding and antecedent steps and pre-qualification criteria, etc., the Constitutional Court thought had simply gone too far. So each organ of state was supposed to come up with its own system, and that it wasn't up to the Minister of Finance to try and regulate all of this through one set of regulations. And ultimately, what was found was that while the Supreme Court of Appeals decision was correct, the Constitutional Court somewhat found that it was correct for different reasons. Their rationale was that the minister had simply gone too far, that the regulations, not so much the content, but that the minister did not have the authority to create overarching regulations applicable to every sphere of government. And accordingly, those regulations were confirmed to have been set aside. And because of that, the appeal was dismissed. Now, this is where things get interesting. The appeal was dismissed on the 16th of February, 2022. I don't have a calendar with me, but let's just go back here. The Supreme Court of Appeal gives this decision on 2 November 2020 and says, government, you've got 12 months to get your house in order and to come up with new regulations. 2 November 2021, that year is up. In that period of the year, this matter goes to the Constitutional Court, and the Constitutional Court dismisses the matter on 16 February. So, under the Supreme Court's ruling, the regulations are gone as at November 2021. February 2022, the Constitutional Court confirms the regulations are gone. So firstly, we have a bit of a question about what applied and what happened between November 2021 and February 2022. We also now have the question, well, what happens from February 22 onwards? Because we're now 5 months later and everybody's still using these regulations. So what does this all mean? That in itself became a highly contentious issue. So the rationale of the thinking of some at the time, and I'll admit I was one of them, was, well, if the appeal was dismissed in the Constitutional Court, that means that the Supreme Court of Appeal judgment stands. And if it stands, well, then it stands to reason that as at 2 November 2021, those regulations are out. No tender can use them, no bidder can make a bid on them, nobody can make an award based on them, they're dead. This proposition was something that the court had dealt with previously in another context many years ago. The Constitutional Court is a cross-border judgment, and that is an issue where cross-border Road Transport Act regulations were set aside. I haven't read them. I don't know what they're about. Those regulations were set aside on the basis that the Constitutional Court found that for whatever reason, they were offensive and they were unlawful. And much like we're dealing with here, the Constitutional Court said, right, the regulations are set aside, but you've got 6 months to get your house in order. So much like we're dealing with in the Supreme Court of Appeal in these 2017 regulations, the regulations under this act are set aside and government has 6 months to try and create something new. By the 14th of August, 2013, the 6 months was up, they became invalid. and they had not been replaced in time. Government slipped up. Government had not promulgated new regulations replacing the old one. And by the 14th of August 2013, under this Constitutional Court judgment, they were gone. So there was no regulations. 2 months later, I don't know what happened for the rest of August or September. Maybe the minister was busy. But in October 2013, an urgent application was brought to the Constitutional Court by the minister saying, whoops, we made a mistake. We didn't get this done in time. Please, can we have an extended period to sort this out? Because we can't have no regulations. That's very dangerous. 6 months wasn't enough time. Please, can we have some more time? And this is a quote from the Constitutional Court judgment. The relevant part is in italics. If the declaration of invalidity, i.e. these regulations are gone, is not suspended, or if the period of suspension has lapsed, a court has no power to suspend the declaration any further. Meaning, what this judgment effectively says is that if an application had been brought on or before the 14th of August, asking for more time, perhaps the court could have helped. But in October 2013, when the minister asked for additional time, the horse had bolted. The 6 months had come, the 6 months had run, the 6 months had gone, and those regulations were out by 14 August. And accordingly, the Constitutional Court could not come to the assistance of the minister. Those regulations were dead 2 months before, and there was nothing that could be done. I had assumed that the same type of rationale would apply in respect of these regulations that we're dealing with. So I thought, well, if we apply that logic, the Constitutional Court has upheld the Supreme Court of Appeal's decision. The Constitutional Court did not grant its own invalidity period. No application was made. When the minister appealed to the Constitutional Court, there wasn't a separate appeal saying, by the way, can we freeze this? And accordingly, I had assumed that by November 2021, these regulations were gone. Many of you might have seen a note that was put out by Treasury in February this year, suggesting the same thing, suggesting that there were no regulations and please don't use them anymore and no bids can be decided on them, etc. And there was a lot of confusion that was caused through that note which got circulated. And that was something that I also had to consider and give effect to certain clients who wanted to know what was happening. See, there's another comment. I just want to look at it quick. Who does procurement regulation reside with? If every organ of state adopts its own regulations, that will lead to disarray, more fraudulent, etc. Surely it's be done with the Minister of Finance. Right. It's a very fair comment. CSI. The question is, if these regulations are now gone and each organ of state must create its own, is that not going to lead to its own problems? It absolutely will. But that's the law. Each department, parastatal, municipality, national department, provincial department, every organ of state is supposed to come up with its own regulations. They might piggyback off each other's, they might copy and paste each other's, that's okay. But they each need to come up with their own. And if any of them come out with something that is improper, seen to be unconstitutional, we might have a series of these types of cases again. But we're getting there. We're getting there because these regulations are still in effect. I'll explain why. So other scholars, legal practitioners, and seemingly Treasury, when they put out the note, had assumed that when the Constitutional Court gave its ruling in February 2022, it upheld the SCA, so these regulations were gone. So what then happened is that the Minister of Finance then brought an urgent application to the Constitutional Court saying, court, we are now very confused. The Supreme Court of Appeal threw out these regulations and they died in November 2021. You confirmed that decision in February 2022. Where does my 12-month invalidity period start? When does my 12-month invalidity period end? How much longer can I use these regulations, or are they already gone? And the court was quite frankly quite condescending on this, and I thought unfairly so to the legal practitioners who brought that, because it's not a straightforward issue. But the court was quite heavy-handed and bullish in explaining almost how stupid the application was, which I thought was a bit unfair. And the judgment reads that with the legal position as plain as it is, I do not understand how the confusion we hear about could have arisen. Quite condescending terminology here. If somebody had bothered to read the rules, they'd have understood. In reference to section 18.1 is made. Now, section 18.1 is with reference to the Uniform Rules of Court or the Superior Courts Act, gives effect to the rules, the High Court rules, the Supreme Court rules, the Constitutional Court rules. And that says, unless a court under exceptional circumstances says otherwise, the operation and execution of a decision, which is subject to an application for leave to appeal or an appeal, is suspended. So that would mean, according to these rules, read with this Constitutional Court decision, that when the Supreme Court of Appeal said your 12 months starts running, and as at 2 November 2020, these regulations are set aside. You've got 12 months to start. Click, the stopwatch begins. The 12 months starts running. The moment the Minister of Finance noted the application for leave to appeal, the time stopped. The 12 months was paused. And then from 16 February 2022, when the decision was handed down by the Constitutional Court, the 12 months starts again. And what that effectively means is that we now have, might not be as far as 15 February 2023, being the 12 months. I don't know how long it took between the Supreme Court of Appeal judgment and the Constitutional Court appeal, let's say a month. So probably by December or January 2023, these regulations are now going to be properly dead. They have already been deemed unconstitutional by the Supreme Court of Appeal because of the processes and the content. The Constitutional Court has found that the minister went too far, acted outside the ministerial powers, and could not create these overreaching regulations that apply to every organ of state. And it's now just a matter of us being on the clock. Government is on the clock. By November, December, January, these regulations will no longer be allowed to be used. So if you are a bidder, you need to start bearing in mind at the end of the year, beginning of next year, that these regulations can't be used. As professionals, if you assist any sphere of government in putting together bid documents, you need to make sure that the bid goes out, that offers come in, and that decisions are made before these regulations are finally set aside. Because if any step in that process is not finally complete, by the time the regulations are set aside, they can't be relied upon. So if a bid goes out referencing these regulations at the time where they're still alive, and the offers come in and the validity period is extended once or twice, and in that validity period extension, the regulations die by virtue of the affliction of the 12 months, you can't make a decision based on them. So where does that leave us? Well, one of two things is going to have to happen. One, an entirely new act is going to have to come into effect, which will replace the very short and very brief PPPF Act altogether. This act here, 90-10, 80-20, goals and points, might be set aside entirely. And as I said a while ago, we in conjunction with the association actually prepared a fairly comprehensive response in respect to the respect of the proposed procurement bill. After we sent that out for public comments, I don't believe anything further has been done. I haven't seen a revised version. Don't know if the association has, but we've seen nothing further on it. Alternatively, new regulations are going to have to come into effect. But as I've indicated, it seems, and as has been pointed out correctly in the comments, each organ of state is going to have to come up with their own regulations. And that has the potential to lead to absolute chaos, because different rules and regulations and law might apply to each organ of state. So be it. We'll have to deal with that as and when it comes. But for now, these regulations can still be used. They are still applicable, but they have been found to be unconstitutional, and they're on their way out. So where we stand now is in a complete state of turmoil. The regulations are ticking down. We haven't seen any further amendments on a proposed new act. We haven't seen further draft regulations applying for everybody. And I personally haven't seen any regulations for any municipalities, provincial departments, national departments, parastatals. And sooner or later, the rubber's going to hit the road, because this is going to be something that is going to become very urgent and very crucial, very much at the last minute, as these things normally do. So to all of you who assist in putting together tenders for any organ of state, you need to start speaking to those organs and asking them what they intend doing about creating a new policy. What is going to be their regulatory framework? Because that needs to be in place. If you're busy putting tenders together and a decision is not taken by, let's say, January, under these old regulations, you can't do it. The whole process has been a waste of time, and that obviously impacts service delivery. And for those of you that are involved in the procurement space, for those of you who tender for work, you also need to bear in mind that it now might get to the point where different municipalities, provincial, national departments, parastatals have their own sets of regulations that you have to comply with. So there's not going to be any more uniformity across all of these organs of state. So that's where we're currently at, and that's potentially where we're heading. See, there's one or two other comments here. Let me just try and deal with them. Sorry, I see there's two chats here. There's a chat and the Q&A chat. France has made a comment here. Much could go wrong until then, made much worse by the reality. There's no real agreements in many sectors that procurement should indeed fall under Treasury. Better accounting profession, worse government rolling out draft procurement bill times, uncertainty. It's rather devastating. Look, that's something we don't have control over. That's something the legislature has to deal with. I agree at a personal level that potentially allowing each sphere of government to create their own policies and rules can be problematic. But that's what the law allows. And unless the law changes, well, that has to be what's given effect to. That's what the Constitutional Court has confirmed. The minister can't create this for everybody. Every organ of state has to come up with their own. I don't believe I've missed any questions. If I have, I'm sorry. Oh, sorry, I see I've missed one here from Milford. Just to ask, what about the CIDB standard for uniformity when it comes in states' appointment of construction sector should be within 15-20% of the budget, or the contractor, please correct me if I'm wrong with percentages. So I don't believe the CIDB Act would apply under the PPPF. So government in most tenders will say you have to have a CIDB score of pick a number and pick a section. So 4 GB or 3 CE or 7 EE. And if the tender itself should stipulate what it believes the risk parameters will be. And if every bidder is 20% under the pre-estimated figure, well, then obviously there's not much risk. But if you've got 12 contractors that are more or less in the same ballpark, and you've got one contractor that comes in, one bidder that comes in 70% lower than the rest, well, then it's fairly clear that there's a risk. And I don't believe there could be any challenge in you trying to disqualify that bidder. But this issue about price thresholds, risk, etc., I think there is an opportunity for government here to fix that. And if any of you are involved close to any spheres of government and you have the opportunity of giving them feedback and input into amending regulations for their specific area, I suggest that's something to be seriously considered. And as the association and as quantity surveyors, you are best placed to do that. You know what prices more or less should be. You know the fat that can be factored in. You know where corners can be cut. You know what is simply too much of a risk and what would be too far gone in terms of ensuring that a project is going to get delivered versus simply be awarded and then fail. And I think that each of you, if you are involved, should be giving feedback to any government departments at any level that you work with, because that is where the feedback needs to come in order to make sure that sensible regulations from each organ of state are promulgated. Unless I've missed anything, Carl, I can hand back to you.
Thank you very much, Peter. That was very, very comprehensive and detailed and great insight into the challenges we face. And it's really good for us to be updated and informed and to know what is going on out there. I think that's really good. Peter, just a question to you. I know that today's subject's not site invasions, but just everything you've spoken about, the 30% and the sense of entitlement, Is this going to resolve, in your opinion, the problem we face in terms of site invasions? Is this going to deal with it effectively?
If new regulations come into effect, or if a new act comes into effect which does away with this mandatory 30%, then those on site would have a legitimate basis to say there is no more 30% basis, you have no right to be here. But I think that is a bit artificial, because what we know in reality is that these business forums have no legitimate basis to be there. The 30% is effectively agreed upfront. You have to follow the CPG process. You have to follow the steering committee. There is already a valid process, and these organizations simply use this 30% expectation as a means of thuggery to force their way onto site. So even if the law changes, I am not confident that that is going to stop this from happening, because now it's just a complete pandemic of these groups coming to sites, shutting the site down, terrorizing people at gunpoint and telling them, give me work, or I'm going to burn your site, kill your family, whatever the threats are. So whilst legislation might potentially go a small way towards solving it, I think that's going to require a lot more police intervention, arrests, and detainment being made in order before proper changes come about and this unlawful thuggery comes to an end. So it would start with the legislature, but I think it's boots on the ground, police making arrests, prosecutors locking people up. That I think is going to make the change.
Right. Thank you very much, Peter. I see one more question is coming here from Sia Sangha. Do you suppose that there would be a review period and process of new regulation?
Yes, there would be. So as I say, the association, and perhaps I'm sure Carl can circulate it to everyone again. We did give some comments on that procurement bill. Gosh, it feels like a lifetime ago now. Carl, might have been a year or two ago. I can't remember how long ago it was. We gave that feedback. We haven't seen anything since. So if amendments are made, then yes, the public participation process would have to come through. If that act is scrapped, if the bill is scrapped and they decide not to go ahead, then each set of regulations that they intend promulgating at each level of government would also have to result in public participation.
Right. Thank you very much, Peter.
Yeah.
Well, that was a very, very productive time together. Appreciate it very much. I'm going to launch the feedback poll as I just say thank you to you again, Peter. We really do appreciate your willingness to spend some time with us as a profession. Just a great appreciation to Cox Yates. You guys are doing amazing stuff out there. I know that you're involved in all sorts of areas, and we just recognize the work that you do, and we appreciate the relationship that we enjoy with you. So thank you very much. Much appreciated.
Thank you, as do I. Thank you all for the time. Thank you for the participation. It means a lot to me. And thank you all for the input. Much appreciated. I'll see you soon.
Thank you. All right, Peter. Go well. I'm going to close the poll. And there we are. Thank you. And to everyone, have a good evening, and we'll see you at the next webinar. Bye-bye for now.